Good day, everyone. My name is Pearl Michelle P. Silvero, and I'm going to tell you all about nature and description of land. Now, what is land? Before we figure out what land is all about, I'm going to tell you a bit of history about it. Great empires were built on it. Bloody wars have been fought over its ownership. American pioneers journeyed far and suffered greatly in their quest to own a piece of it. Humorous Will Rogers often advises audiences to, quote unquote, buy land. They ain't making any more of it. The preamble to the National Association of Realtors Code of Ethics begins with the phrase, under all is the land. Our homes are built upon it. We are nourished by the fruits of it, and we derive our incomes from it, either directly or indirectly. We may cultivate it, redefine its use, or even affect it adversely through our own folly, yet it remains permanently under our feet. It is without a doubt the single most important commodity known to humanity. The real estate business centers around the ownership, possession, and transfer of land. However, as you will learn more in this chapter and in the following chapters, land is more than just the earth we walk upon. The ownership and possession of land brings into play a body of highly complex laws that define the various rights and interests of property owners, third parties, and the general public. Land is further affected by local, state, and federal laws and court decisions that regulate the orderly transfer of real estate. Next, we're going to talk about bundle of legal rights. As I have no further knowledge about this topic, I have asked my dad, Michael T. Silvero, Reb Rea, MMEP, to help us further on discuss about this topic.
Okay, so the topic is bundle of legal rights, commonly known as bundle of rights. From the word bundle, now basically there are seven absolute rights that is considered as bundle of rights. Now, if you have what we call as the right of ownership, it means that the property is at fee simple. Fee simple. The word fee simple constitute a state of ownership where all of this bundle of rights is inherent with it. Now, there are types or kinds of rights of ownership or the bundle of rights. So, here it is, the right to possess. It is actually in Latin, jus possidendi. The right to dispose, which means that you can actually sell at any time your property. Jus dispodendi. Possession is utendi, jus utendi. Exclusion, it is also your right. Have you noticed that if someone actually tries to occupy your ownership land, you can actually let them be evicted because they are what we call as squatters. You can also lease it. It's part of your right. The right of control and the right to enjoy. That's it.
Thank you, Dad, because not gonna lie, I have no prior knowledge about that topic. So, now let's talk about property rights. The word property refers not so much to the article owned, but more importantly, to the rights or interests involved in its ownership. Ownership of property in general, and real estate in particular, has often been described as a bundle of legal rights. In other words, when a person purchases a parcel of real estate, he or she is actually buying ownership rights previously held by the seller. As you can see in our figure, you will see the rights of ownership. These rights of ownership include the rights of possession, control within the framework of the law, enjoyment in any legal manner, exclusion, to keep others from entering or occupying the property, and disposition, to be able to sell or otherwise convey the property. Within these ownership rights are included further rights to sell, will, devise, mortgage, encumber, cultivate, explore, lease, license, dedicate, give away, share, trade, or exchange. However, one's ownership is subject to any rights that others may have in the property. The various rights and interests in property ownership will be discussed in detail in Chapter 2. You may have heard of the terms land, real estate, and real property used interchangeably. Though they may seem to be describing the same thing, there are important subtle differences in their meanings. First, one must understand the meaning of real estate as it differs from real property. Real estate refers to the land and all those items which are attached to the land. It is the physical, tangible entity together with all the additions or improvements on, above, or below the ground. Real property, on the other hand, includes all the rights, interests, and benefits related to the ownership of real estate. Now, Article 419 of the new Civil Code classified property as either public domain or private ownership. Now let's talk about land. Now, land is commonly thought of as the ground or soil, but from a legal standpoint, land ownership also includes possession and control of the minerals and substances below the Earth's surface, together with the airspace above the land up to infinity. Thus, land is defined as the Earth's surface extending downward to the center of the Earth and upward to infinity, including those things permanently attached by nature, such as trees and water. Now, as you can see here in our figure, I will discuss furthermore about what these are, such as the air rights, surface rights, and subsurface rights. The term real estate is somewhat broader than the term land, and it includes not only the physical components of the land as provided by nature, but also anything that is permanently affixed to the land by either natural or artificial attachment. Items attached to the land by a root system are considered natural attachments. Fructus naturalis, or real property, are products of the earth that are naturally grown and require no annual labor or cultivation. Such examples are trees and bushes. Next is fructus industrialis, meaning personal property, are products of the earth that require annual planting or cultivation, such as unharvested wheat or vegetables. Now I'm going to highlight the keywords to differentiate between the two. Now I'm going to tell you about artificial attachments. They are also called as improvements, and are normally those things that have been placed on the land by people. Improvements may be embedded in the land, such as walls, footings, in-ground swimming pools, and water or gas lines. Sometimes they're also placed or resting upon the land, such as building slabs, driveways, streets, and patios. Another improvement is erected on the land, such as buildings and towers, or any other man-made additions to property. Therefore, real estate is defined as the Earth's surface extending downward to the center of the Earth and upward into space, including all things permanently attached to it by nature or by people. As you can see here in our figure, you can see a visual aid of what real estate is. Now you might ask, what is the difference between real estate and land? Well, I will highlight it for you. Simply, real estate is permanently attached by nature or by people. On the other hand, land is by nature only. Now, in practice, the term real estate is most often used to describe that commodity with which real estate as a business and the real estate broker and salesperson are concerned. Now, this is sometimes referred to as realty. Previously, I have talked about Article 419 about public dominion or private ownership. Now I'm going to further explain it. It is public domain if it is intended for public use, public service, or the development of the national wealth. The keywords are public use, can be used by anyone, and public service can be used only by those who are authorized by competent authority. When a property is of public dominion, it is outside the commerce of men and therefore cannot be acquired by prescription. Property of private ownership, besides the patrimonial property of the state, provinces, cities, and municipalities, consists of all property belonging to private persons. Patrimonial properties are those properties of the state or other public corporations which are not intended for public use or for public service. They are held by the state for private or business capacity. Know everyone. No, I don't like that. Know everyone. Please to remember that the classification of property in relation to the person to whom it belongs to is in whether it is of public dominion or private ownership. The property of private ownership, besides the patrimonial property of the state, provinces, cities, and municipalities, consist of all property belonging to private persons. Now let's talk about the determining factors to distinguish between public dominion or private ownership. First off, let's talk about that our Constitution adopts the Regalian Doctrine. Now, what is this, you might ask? Well, with respect to the natural resources of the country, this doctrine holds that all minerals, coal, etc., found either in public lands or in private lands belong to the state. The adoption of the Regalian Doctrine was considered a necessary premise for the recognition of the power of the state to control the exploration, development, and utilization of our natural resources. Under this doctrine states that all lands of the public domain belong to the state, and lands not otherwise appearing to be clearly within private ownership or presumed to belong to the state, unless public land is shown to have been reclassified as alienable or disposable, and subsequently alienated by the state. It remains part of the public domain. Occupation or possession thereof by a person in the concept of ownership, no matter how long, cannot ripen into ownership. Now, in simple terms, the Regalian Doctrine is everything in the country without a registered owner is owned by the state. Where does the Regalian word come from? It comes from the root word regal, which means royal or royalty. There's also the principle of res nullius. Everything in earth must have an owner. It comes from the Latin word res, meaning things, and nullius, without an owner. Example, fish in the ocean or wild animals. Please do take note, since everything must have an owner, if there are no private claimants or owners, then that particular property is presumed to be owned by the state. Likewise, when a person dies without any heir, then the state succeeds to the estate of the deceased. A quick little add-on about land ownership. It is the right and interest that a person has in land to the exclusion of others. It is the independent right of exclusive enjoyment and control over land for the purpose of deriving therefrom all advantages required by the reasonable needs of the holder of the right and the promotion of the general welfare, but subject to the restrictions imposed by law and the rights of others. Please take note of the bolded words. Now let's talk about real property. The term real property further broadens the definition of real estate to include a bundle of legal rights involved in real estate ownership. Thus, real property is defined as the Earth's surface extending downward to the center of the Earth and upward into space, including all things permanently attached to it by nature or man, as well as the interests, benefits, and rights inherent in its ownership. I will highlight the keywords for you. It is quite similar to land and real estate, but this is including interests, benefits, and rights inherent in its ownership. As you can see, the concept of real property ownership involves more than just the rights to use the surface of the earth. It also includes the rights to those things appurtenant to the land. An appurtenance is defined as anything that, by right, is used by the land for its benefit. Such rights include subsurface or minerals rights, air rights, easements, appurtenant, and water rights. Now let's discuss about Figure 1.2, the land or real estate. You can rewind the video to see the figure. We're going to talk about subsurface or mineral rights. Ownership of real property includes rights of ownership in all minerals and other substances located below the surface of the land. Now, for example, a landowner might sell an oil company his or her rights to any oil and gas found in the land. Later, the same landowner can sell the property to a purchaser in the sale reserved for the rights to all coal that may be found in the land. After these sales, three parties have ownership interests in this real property. Number one, the oil company, who owns all oil and gas. Number two, the seller, who owns all coal. And lastly, number three, the purchaser, who owns the rights to all the rest of the real property. In the absence of an agreement to the contrary, any individual acquiring the rights to the minerals in the subsurface also what is known as implied easement, which allows the holder of the subsurface rights to come back onto the surface of the land for the purpose of removing the minerals. Now, easements will be further discussed in Chapter 2. Now let's discuss about air rights. As with subsurface rights, the rights to use the air above the land may be sold independently of the land itself. Air rights are an increasingly important part of real property, particularly in large cities. Huge office buildings like the Pan Am Building in New York City and a Merchandise Mart in Chicago have been built over railroad tracks. For the construction of such building, the developer must purchase not only the air rights above the tracks, but also numerous small portions of the surface of the land in order to construct the building's foundation supports. Now, those are called caissons. The caisson locations are regularly spaced between the tracks and are usually planned to rise about 30 feet above the tracks so that the finished foundation supports do not interfere with the operation of trains on the railroad remaining land ownership. Until development of airplanes, a property owner air rights were considered to be unlimited. Today, however, the court permit reasonable interference with these rights, such as is necessary for aircraft, as long as the owner's rights to use and occupy the property is not lessened. Government and airport authorities often purchase air rights adjacent to an airport to provide glide patterns for air traffic. Now, these rights are particularly important in urban area, as I have mentioned, in large cities. In many cases, buildings are constructed within identified airspaces. However, air rights are limited to a reasonable distance and the rights of others above the surface of your property. Now, for example, you cannot own the rights of an airplane passing through your property. But, however, you can claim rights where you are prevented from enjoying your air rights when an airplane flying too low that a reasonable use of the land is prevented or crops are damaged. Nowadays, airspace can be sold. For example, an office building erected above the tracks of railroad may sell the air rights over the building. Next, let's talk about water rights. One of the interests that may attach to the ownership of real property is the right to use bodies of water. Now, in the United States, the ownership of water and the adjacent land is determined by the doctrines of riparian rights, littoral rights, or prior appropriation. Navigable waters are considered public highways on which the public has an easement or right to travel. Thus, the land is generally owned to the water's edge, with the state holding title to the submerged land. Many states subscribe to the common law doctrine of riparian rights. These rights are granted to owners of land located along the course of flowing water, such as a river or stream, and owners who have located within the subsurface of their land. Such subsurface water is known as percolating water, and the level at which such water is located beneath the surface of the earth is called water table. Riparian owners have the right to make use of the water for irrigation, swimming, boating, fishing, or any legal way that does not interfere with the same rights of owners downstream. In addition, an owner of land that borders a non-navigable waterway owns the lands to exact center. The laws governing riparian rights differ from state to state, so it's not always the same. Closely related to riparian rights are the littoral rights. It is whose land borders on large navigable but non-flowing lakes and oceans. Now, these owners may make reasonable use of the available waters but only own the land adjacent to the water down to the mean high water mark. I have highlighted down on what you should take note of. Now, in states where water is scarce, the ownership and use of water is often determined by the doctrine of prior appropriation. Now, under this prior appropriation, the right to use water for any purpose other than limited domestic use is controlled by the state rather than by the adjacent landowner. However, ownership of the land bordering bodies of water is generally determined by the rules for riparian and littoral ownership. Another note is that property purchasers are also interested in potable water, or safe water, and agreeable for drinking that is available on the property. So if you have a potable water nearby, it is high likely the case that a purchaser is interested. Also, I just want to add, because the definition of water rights I gave earlier was mostly about the America or United States, well, did you guys know that there is a law governing the use and ownership of water in the Philippines? Well, this is PD 1067, otherwise known as the Water Code of the Philippines. The code covers underground water, water above the ground, water in the atmosphere, and waters of the sea within territorial jurisdiction of the Philippines. I'm going to simplify the following objectives of this water code. A. To establish the basic principles and framework relating to the appropriation. B. To define the extent of the rights and obligation of water users. C. To adopt a basic law governing the ownership. And lastly, to identify the administrative agencies which will enforce the law. Now I'm going to tell you all about real versus personal property. There are two kinds of real property. One is real estate, the second is fixture. And there are also two kinds of personal property. We got the trade fixture and the personal property. Now we're going to talk about real versus personal property. Real estate, land and anything permanently attached to it. Fixture, item that was once personal property but since converted to real estate by permanently attaching it to the real estate. Note, it may not be removed by tenant or by the seller. And the personal property, movable items not attached to real estate, items severed from real estate. So there's no way near attached to real estate. A trade fixture, item of personal property attached to real estate that is owned by a tenant and is used in a business, legally removable by tenant. I will further discuss on what a fixture is, what a personal property is, and the rest. Fixtures, real property is by definition immovable. So, personal property that has been affixed to the land or to a building so that it becomes immovable is by definition real property. The law construes this addition to be a part of the real property known as fixture. Courts apply 5 tests to determine whether an article is a fixture or personal property. Number 1, method of attachment. 2, agreement between the parties. 3, relationship of the parties. 4, intention of the parties. And lastly, 5, adaptation of the article to the real property. Now, to help you remember the test, the first letter of the 5 tests spell the name Maria. It's very easy to remember the 5 tests to a fixture. 1 is method. The permanence of the manner of annexation or attachment often provides a basis for court decisions relating to fixtures. Now, for instance, a furnace. Although it is removable, it's usually attached in such a way that it cannot be taken out without causing extensive damage to the property. Moreover, the furnace is considered an essential part of the complete property and as such, a fixture. Next is agreement. The existence of an agreement between the parties involved as to the nature of the property affixed to the land is normally the first test to be applied by the court. If the existence of an agreement can be established, all other tests are generally discarded. Now, for instance, if an agreement clearly stated that the tenant could remove any articles he or she attached during the lease term, the court would infer that this agreement should be followed because the parties had displayed sufficient foresight to anticipate the problem. A good example of this is a tenant would not like the laundry that is already installed, which is a fixture, and they don't want it, and they have agreed to it. So, that means all other tests are generally discarded. Next is relationship. The relationship between the person who adds the article and the person with whom a dispute arises is another test applied by the court. The relationship is typically between a landlord and a tenant, or a seller and a purchaser. Fourth is the intention. Now, the intention of the parties at the time of an article was attached is a very important factor in deciding whether or not an article is a fixture. For instance, a tenant who opens a jewelry store may bolt her display cases to the floor and later remove them. Since these items are an integral part of her business property and it was never her intent to make them a permanent part of their structure, they would be considered personal property essential to conducting a business, or trade fixtures. It should be noted that tenants must remove all trade fixtures before the expiration of the lease. After the expiration of the lease, the tenant has no right to come back onto the landlord's property to remove trade fixtures. So, if you were renting and then you left your belonging to that property, you cannot go back and get it because the tenant has no right to come back onto the landlord's property to remove trade fixtures. So that is unfortunately in the law. Fifth is adaptation. The adaptation of the article to use in a particular building is another test of the nature of the article. For instance, air conditioners installed by a tenant into wall slats specifically constructed for that purpose would be considered fixtures, even though they could be removed. Likewise, storm windows custom-made for a particular house would be considered fixtures even though they could be readily removed. In addition, all the integral parts necessary for the operation of a fixture are considered real estate. Now, examples are house keys, garage door openers, and a remote control of a built-in TV. Now, it is very clear from these tests that it is possible to convert an item of personal property into real property. It is also possible to convert real property into personal property. For example, a growing tree is real property. But if the owner cuts down the tree, severing it from the land, the tree becomes personal property. Likewise, clay existing in the subsurface of the land is real property. But if the owner mines the clay and mills it into bricks, the bricks are considered personal property. Do you understand now? The final question to be asked is this. Once the tree has been severed and milled into lumber and the clay has been milled into bricks, becoming personal property, can either once again become real property? The answer is yes. Now, if the lumber and bricks are used in the construction of a house, they become real property again. Replacement trade fixtures. When a tenant replaces worn-out fixtures, the replacements become real property and remain as part of the owner's property. An example for this is a tenant leasing a tavern replaces the old bar with a new one. That tenant may not take the replacement out at the end of the lease term. The replacement trade fixtures, it can also relate to the fifth task, which is the adaptation. We're done talking about fixtures, so now let's proceed to personal property, also called as chattel. It is considered to be all property that does not fit the definition of real property. Personal property has the unique characteristics of being movable and includes such items as furniture, clothing, money, stocks and bonds, notes, mortgages, leases, trade fixtures, annual flowers and plants, and growing crops, or embezzlements. You can also see figure 1.3, rewind the video, to see the definition of personal property as I've said before. Next is trade fixtures. It is an article attached to a rented space or building by a tenant for use in conducting a business. While fixtures are legally construed to be real estate, trade fixtures are considered personal property. An example of this are bowling alleys, store shelves, restaurant equipment, and agricultural fixtures, such as chicken coops and tool sheds. Trade fixtures must be removed on or before the last day the business property is rented, or they become the real property of the landlord. I mentioned embezzlements earlier. Well, those are growing crops that are produced annually as a result of someone's labor, or as we call it, fructus industrialis, as I discussed earlier. Embezzlements are regarded as a personal property even prior to harvest. Thus, a tenant farmer has the right to take the annual crop resulting from his or her labor, even if the harvest occurs after the lease has expired. A landlord cannot terminate a tenant farmer's lease and not give the tenant the right to re-enter the land to harvest his or her crops. Unfortunately, I don't have much time to talk about the characteristics of real estate and further on. So, I'll see you guys in the next video. Thank you for watching and listening. Bye bye. I seriously need sleep. Help.